3, 2, 1.
This Honorable Court of Appeals of Tennessee is now in session.
Good afternoon. Before we start, just a comment or two. We don't anticipate any technological problems, but if something should arise, just make sure we're apprised of it, and we'll take a short pause, and our experts on it will get it resolved, and then we'll move forward. Mr. Chairman, call the case, please.
Hunter Ryan Ellis et al. Versus Christina Duggan et al.
We'll hear from the appellant.
Thank you, Your Honor. My name is Michael Thomas with the Chattanooga Bar, and I represent the appellant, Christina Duggan. Right off the bat, it's important to note that this case can be decided on one issue alone. Did the decedent receive competent, independent advice from the Chambliss firm? If the answer is yes, then all of the other analyses do not matter for the purpose of deciding the outcome of this matter pursuant to the Richmond case, which states that when the burden transfers to the defendant, in this particular case, the appellant, they have the duty to prove the fairness of the transaction. The Richmond case stated that if they are able to prove that competent, independent advice was received by the donor in this case, then that will rebut the presumption of undue influence. Now, this is not to acknowledge or admit that the appellant unduly influenced the deceased. We state it because the appellees are going to ask you to follow them down a detailed journey of facts as they see them. And that should not be required if it's clearly shown that there was competent, independent advice. The relevant facts of the transaction and advice given by the Chambliss firm are as follows. The decedent and the appellant had been in regular discussions about the purchase of a house for the appellant. More than one residence was considered by the appellant, and the decedent herself visited a previous house and even rejected a previous home that she had visited. On July 30th, 6 people, including the appellant and the decedent, visited a home. After touring the residence, the appellant and the decedent liked the home, and the decedent instructed the appellant to make an offer and even told the appellant how much to offer for the home. At this point, the offer was accepted by the seller, and the decedent instructed the appellant to draft a check for $1,000 as earnest money, and the decedent herself signed the check. Now, the appellant was the one who actually signed the contract for herself, not on behalf of the decedent. The next day, on July 31st, the appellant felt uneasy about the transaction based off of family infighting in the past and contacted the Chambliss firm here in Chattanooga, specifically Sally Brewer, and informed her about the transaction and asked the firm to confirm that the transaction was what the decedent actually wanted and that she had the ability to make the transaction. From this point forward, the appellant was no longer involved with the decedent and her attorneys with respect to the transaction. The Chambliss firm took over. Ryan Berry, the attorney handling the decedent's estate with the Chambliss firm, spoke with the decedent several times as he testified to on the phone to confer with her about the transaction, her being the decedent. Mr. Berry testified in part that he made sure that the decedent wanted to make the gift, informed her about the tax consequences to her estate and what would need to be done with respect to those tax issues. He also informed her that once the gift was completed, it could not be undone. Additionally, Mr. Berry knew about the infighting among the family members as well and sent another firm employee, Sally Brewer, a qualified dementia care specialist, to test the decedent for competency, among other matters, which he included in his testimony, which can be found in our reply brief. So we don't have to go into too much detail about what was said during this argument. Ms. Brewer met alone with Jean for a period of time, performed a mini cognitive screening and a St. Louis test on the decedent. She also noted that she did not appear, she being the decedent, did not appear to be unduly influenced as to the transaction, which Ms. Brewer explained in detail during her testimony at the trial court. After the test, she called Ryan Berry, and then the three of them, Ryan, Sally, and the decedent, spoke for an additional 20 minutes about Jean's estate in general. Sally signed off on Jean's mental state and the documents were signed. And I say documents because there were multiple documents signed during, or two documents, I should say, that were signed during this meeting. One was the transfer and assignment document, which is the subject of this appeal. And the other was an executive directive regarding property to another grandchild, which was not at issue in this case. 12 days later, after this meeting and after the transfer and assignment was executed, the appellant posited the $175,000 check that had been drafted on the decedent's account and used it to purchase the home. Now, the trial court's opinion wants you to believe once the check was drafted and signed by the decedent, that the transaction was complete prior to the firm ever getting involved. We do not believe that is true. There were insufficient funds in the account to cover the check. Only after the decedent met with Ryan Barry and on the morning of the screening did the appellant even begin the process of transferring funds into the checking account to cover the check.
Let me, I think I understand it here, but did Mr. Barry ever meet with her in person?
Not in person, Your Honor. It was all over the phone.
Had he ever met with her in person?
I cannot answer that off the top of my head. I believe that he had been handling her estate since prior to 2012, and I do believe that he was involved with some meetings with Miss Ellis and Steve Jett, the previous attorney who had been handling her account prior to it being transferred off to Ryan Barry. So I guess the answer to the question actually is yes, he had met with her prior.
But he didn't meet with her in this period of time when he was talking to her about this transaction?
No, Your Honor, not during these 5 days.
All right, go ahead.
Before Ms. Duggan, the appellant, transferred the money into the account, she did ask Grady Williams, the decedent's longtime CPA, which funds she could use to transfer into the checking account. Mr. Williams was adamant that she not use any funds from the trust for obvious reasons, because that would obviously violate the terms of the trust. She settled on the annuity funds and even testified that she asked the decedent prior to cashing out those funds to make sure that that was what she wanted. This is another important factor. The appellant is a layperson with no legal background. It's important, we feel, for the court to note that before she did anything major involving Jean Ellis during the entire time she was attorney in fact for the decedent, she would contact Jean's attorneys first and ask the question, which is exactly what we want our attorneys in fact to do when they don't know what's going on. So the chancellor notes this even throughout his opinion, how the appellant would even contact the attorneys whenever anything would come up. Now,
Mr. Thomas, on that annuity check, somebody forged the decedent's name, correct? But nobody ever copped to it. Is that fair?
Your Honor, I don't believe that there was ever a finding that was forged in the opinion. There was a lot of testimony about who signed it and about whether the decedent signed it or not. The power of attorney, the appellant, stated that she didn't sign the check, and her sister stated that she didn't sign the check. No expert witnesses were brought forward to show that anyone other than Jean Ellis signed the check. However, there just was no finding, actually, to answer your question. Which gets us into another point. I don't think we're here to second guess the advice given by the Chambliss firm. Had Ryan Barry and Sally Brewer, the dementia care specialist, stated that the facts that the appellees are going to show you would have changed their opinion as to the transaction, those facts might be relevant. But as stated by Ryan Barry with the Chambliss firm, those facts didn't change his opinion as to whether he properly advised Jean Ellis. The question was not how the transaction was to be performed. It was whether Jean wanted, or the decedent wanted it done, and whether Jean had the ability to do it. Jean certainly possessed enough funds to cover the gift, with the testimony that her estate held approximately $3 million at the time this check was drafted, and approximately $1.8 million or so at her death, in addition to separate funds in a marital trust for her benefit.
Counsel, the trial court made various credibility determinations, correct?
Correct, Your Honor.
Found the caregiver's credible?
Correct, Your Honor.
And did the caregivers testify contrary to, and I can't remember her name, the woman from the firm who came and met with her, the decedent?
No, Your Honor, there was one statement from, I believe, Rose Melton that stated that Judy Morgan was present, the decedent's sister. However,
They sat on the porch and discussed it.
well, when they arrived, Rose Melton testified that after the decedent went back into the room and when the meeting started, she left and was no longer even in the room or within the house. I believe she said she was out wandering the grounds somewhere. Sally Brewer testified adamantly that it was just her and the decedent alone in the room during the cognitive screening and the subsequent meeting with her attorney.
Your Honor, before I proceed, I don't know if y'all realized it, but we lost the feed from 6:19 of the argument to 2:15 of the argument.
I'm sorry, you lost from what?
We completely lost the feed and we're off of the Zoom meeting for 4 minutes between
4 minutes?
between the 6:19 mark to the 2:15 mark before we were able to get back on. We tried to call Mr. Hivner at the number that was provided, but were unsuccessful. So I don't know how I'm supposed to proceed, although I'm happy to make my argument. I may not be able to respond to things that I've heard.
Anyone have any suggestions?
I say you just move forward with your argument, Mr. Moss.
Judge McGee?
I agree. I don't know how to do anything else at this point.
Well, I don't really either. I certainly don't recall what happened, what the argument was at that 4 minutes or so.
I don't think it was anything that was not contained in the brief, so there was nothing new thrown at us.
Okay. Let's proceed that way.
All right. Thank you, Your Honor. Please, the court. My name is David Moss, and along with Linda Norwood, we represent the plaintiffs below, the appellees in this court, who are the grandchildren, and one is a great-grandchild of Gene Ellis. And we won the case at trial because there was overwhelming evidence to support our position in the judgment of the trial court. And you have a fairly compelling record before you. Most of the plaintiffs in undue influence cases must rely entirely upon suspicious circumstances to prove their case. We have them here. In fact, we have 11 suspicious circumstances, all of them shown at trial. But we have more than that. We have more than just suspicions. We have testimony of independent and unbiased witnesses who were accredited by the trial court and who testified to the pressure that was placed on Gene Ellis by Ms. Duggan and her mother, Judy Morgan, to the misrepresentations and ruses that they used to bring about this transaction, to the secrecy that was employed. And there is a paper trail that your honors have showing Ms. Duggan's history of grasping for ownership and control of Gene Ellis's property, showing that the idea of this transfer originated with Ms. Duggan, showing that Ms. Duggan's active involvement she actually orchestrated this transaction, and showing that the forgery that was necessary in order to consummate it. Now, I'll take just a few minutes to recap that evidence before I move on to rebutting the argument that I heard begun a few minutes ago. But I do want to recap some of this. Now, we know that there was a power of attorney, a durable general power of attorney that was given by Ms. Ellis to Christina Duggan, which was repeatedly used because she was over all of her financial matters. She did transfer property for her. She did many things using the power of attorney. So there was a confidential relationship as a matter of law. And we know that there was a transfer from the servient party to the dominant party, which triggered the presumption of undue influence and shifted the burden of proof in this case from the plaintiffs to the defendants to prove the prove the fairness of the transaction to Jean Ellis. And they chose to do that by trying to prove that she received proper independent advice. I'll get to that in a moment, but I did want to mention the other 9 suspicious circumstances that also exist in the case. She was of an advanced age, 83 years old. No, there's no dispute about that. She was deteriorating mentally and physically. There's no argument about that. The independent witnesses testified to her susceptibility to whoever was around her because of these mental and physical conditions. And there was even evidence about Ms. Duggan's use of that condition because Nick Ellis, who was accredited by the trial court, testified that Ms. Duggan had told him, Nick, if you want to get your house, do what I do. Give Jean a hydro, meaning hydrocodone, when she was even more susceptible to influence. We know that Ms. Duggan was actively involved in the transfer. This is probably ad nauseum in the briefs, but from the writing of the checks to the holding it because she knew it was unfunded, to the efforts to try and get the funding of it. The things that I'd want to point out to you, though, that under that topic is that the trial court found that this self-gifting, first of all, this check that she wrote for the escrow money where she signed on Jean's account as power of attorney was a clear violation of the power of attorney document itself. And the court found that that was a breach of her fiduciary duties. I'd also point out that she used that power of attorney to liquidate an investment in order to fund a gift to herself. Ms. Duggan was doing that. And she is the one who contacted Chambliss Bonner after the fact and asked Chambliss Bonner to document the transfer to protect her, Ms. Duggan. In other words, Ms. Duggan is asking Chambliss Bonner to document a transfer to protect Ms. Duggan, not Jean, but Ms. Duggan. There are other ones, the misrepresentations, the ruses that were used. You heard from the caregivers testified about that. We've talked about the forgery also that was on the back of the deposit, Jean's signature. There was no testimony that was Jean's signature. Everybody said that's not her signature. Somebody forged her signature, and the trial court specifically said that he did not believe Ms. Duggan's testimony, that she did not know who forged Jean's endorsement or how that prudential annuity check got deposited into Jean's account. That's in the judgment. So then you had that beyond that, the secrecy that the trial court was very concerned about. And there are so many things to talk about there, but the main things are that he specifically found that Ms. Duggan carefully and deliberately concealed her actions from the plaintiffs for fear that she would not be able to consummate the transfer if her plan was known. And you might remember that there was express testimony from one of the caregivers who was accredited that Ms. Morgan, when she picked up the annuity check, said, "Don't tell Rick or anybody." That's clear evidence that they were hiding this transaction. There was evidence that she was anxious and indecisive at the time that this meeting took place with Ms. Brewer. There was evidence that this transfer was contrary to Jean's will. It was contrary to the liquidation of the annuity, was contrary to the express name beneficiaries who happened to have been our clients, whose annuity was liquidated by Ms. Duggan to fund her own transfer. And of course, the trial court expressly found that Ms. Duggan failed to meet her burden of proving by clear and convincing evidence that that Jean received proper independent advice. The trial court found that this whole idea originated with Ms. Duggan. He said in September of 2013, 2 years earlier, she came to Chambliss Bonner trying to find out if the trust could buy her a house that would revert to her after Mike Sr. died. You got Mr. Jett saying that's out of bounds. They say it looks like she's trying to self-deal, but the trial court pointed out that this casts into doubt any notion that the funds for the house were Jean's idea. So the trial court found, as a matter of fact, that this originated with Ms. Duggan. Now,
Mr. Moss,
yes, ma'am.
let me interrupt you for a moment and go in a little bit different direction. The appellants alleged that there was a stipulation in regard to the decedent's competency, that the parties stipulated as to that prior to the beginning of the trial. Is there such a stipulation in the record?
I don't remember. I thought I had told opposing counsel this and the court. I don't remember a stipulation to that effect, but we've always gone under the presumption that undue influence presupposes that someone has testamentary capacity. So when we're talking about competency or testamentary capacity in this case, we've never contended that she lacked that. We're saying that she was unduly influenced to make the transfer. Those are two separate issues, as one of the courts that the Supreme Court has said. This question of what somebody wants to do and whether they're competent to make a transfer is one thing. Whether the idea or the intent was created by the transferee, resulting in undue influence, that's a separate issue. Does that answer your Honor's question?
It does. Thank you.
Okay. I would like to address the fairness issue, and of course, they're relying upon independent advice. The trial court found that Ms. Duggan did not meet her burden of proving proper independent advice. And in our brief, I don't remember the exact page, but we cited the Supreme Court has basically said that proper independent advice is something more than a cursory discussion of the transaction or asking if the transferor intends or desires to make the transfer. Proper independent advice, and I forgive me for reading, but I wanted to make sure that I read this correctly. Proper independent advice consists of the transferor conferring fully and privately regarding the proposed transfer before the transaction takes place, and they're consulting with someone who's disassociated from the transferee, who is competent to give complete and correct advice. That means that they've got to know the material facts, and that they do in fact provide that advice about the legal effect, consequences, and advisability of the transfer. So the person not only has to know the relevant facts surrounding the transfer itself, but they have to know enough about the person's financial situation to be able to make judgments about whether this is advisable to them or not. And in each one of those things, there was a failure. The undisputed evidence is that Jean had already transferred and delivered the check before Chambliss Bonner is even in the scene. That was always because Ms. Duggan was asking Chambliss Bonner to document it for her benefit. But it was over as far as Jean's involvement was concerned. So there wasn't advice before. They haven't met their burden of proving the privacy. They have to prove that by clear and convincing evidence. His evidence, Mr. Berry's evidence, was, I don't know. I don't know if anybody was on the line with her. I don't know if Ms. Duggan was present. I don't know if Judy Morgan or the caregivers were present. I don't know. And there was the conflicting testimony that I caught the end of earlier that y'all were talking about, where Ms. Milton said that they were all meeting out on the sun porch together. Now, disassociation. There was a clear conflict of interest. And Chambliss had its own business relationship with Ms. Duggan. Brewer was her friend. That's who she's doing all the communicating with. And of course, the court pointed that out. She's not calling Barry, she's calling her friend, Ms. Brewer. Ms. Brewer is not an attorney, and she doesn't know when she testified. She doesn't know anything about what is undue influence from a legal standpoint. And I can tell you, Ms. Jean at her age didn't. But the point is that they did not. They were not disassociated. Ms. Duggan initiated this. She thought they were working for her. She even wrote an email saying later, will you document a transfer of another house to my mother, but just like you did for me? That's what she's saying to Sally Brewer. So she thinks they're working for her. And in fact, Barry testified that they were vicariously representing her. So they had a conflict. We don't think that establishes the disassociation. And proper independent advice, there was no testimony that he ever inquired as to how this idea originated. There is no question that he never discussed the consequences of this to her estate. I'm so sorry, I'm down to my last minute, and I did want to remind the court that we asked for attorney fees, and there was evidence of both breaches of fiduciary duty and undue influence, and therefore those attorney fees are supported. We're not saying Mr. Berry's a bad guy, but he was looking the wrong way, and he wasn't paying. He was inexperienced and looking the wrong way. Thank you.
Thank you, counsel. We'll hear from the appellant in rebuttal.
Thank you. With respect to the breach of fiduciary duty, Mr. Moss was citing to the trial court's misquoting of a key witness in this case, attorney Ryan Berry. Mr. Berry stated that the POA allows the attorney, in fact, to make a gift, even to the attorney, in fact, herself, so long as it was at the direction of the principal. The trial court stated that Ryan Berry testified that she could not, the attorney, in fact, could not make a gift to herself, even at the direction of the principal. I've gone in and shown your honors in my brief where that was a misquote of the record and have attempted to correct that to show that the trial court made a mistake of not only testimony, but as law as to the interpretation of the POA and what could be properly done thereunder.
Well, Mr. Berry's interpretation of it as a question of law isn't gospel, is it?
Correct, Your Honor. However, the trial court hung its hat on that and agreed with them as well. So with respect to that, we feel that your honors have the ability to review the power of attorney itself and make your own determination de novo as to whether that was in fact a breach of fiduciary duty. With respect to the statement involving vicarious representation, yes, he said that, but that's just a little part of what he said. He vicariously represented her because she was the attorney in fact and would have to speak to her, the appellant, because of the relationship with the decedent. However, when anything involving Ms. Duggan came up individually, the testimony also went on to say that the firm was very quick to say, hey, we don't represent you. We can't do this for you, or this is improper at this point. Going back to previous questions to them, with respect to a question back to 2013 referenced by Mr. Moss, we feel that evidence should have came in. We objected to it at trial as it was outside the issues being brought forward in this particular case, and they attempted to rely on what appear previous bad acts or motive, whatever it may be, to show that the appellant was doing something wrong. maybe the defense made a mistake in focusing solely on competent independent advice and not wanting to get into a mudslinging with facts of trying to twist facts one way or another. We just asked the court to take a look at not how the question was twisted to make it look like a nefarious act, but look at the fact that the question was asked to begin with. Can I do this? How do we make this work? The question was asked if she could get on the account. The question was not whether really she needed to be on the account. It was whether she could manage some assets for the decedent and possibly the demented child. And once it was determined it couldn't be done that way, the firm and the attorney, in fact, got together to find out the correct way to do it, as is what we want our lay attorneys, in fact, to do, to ask questions, to not run off and do things on their own, but to make sure what they choose to do is the proper thing to do. I applaud the appellant for doing these things, for asking these questions. And it's a shame that she's being second guessed for making sure that she asked these questions by having these questions turned around on her after the fact that show that she has some nefarious intent that's been going on for years. At this point, Your Honor, about 1 minute and 15 seconds left. Do you have any questions for me?
I hear none.
Well, at this point, I believe the remainder of my argument is contained in both my briefs, and I'm more than happy to direct you there so we don't have to waste the court's time at this point.
Thank you. We appreciate that. Our thanks to counsel, all counsel involved for the oral argument and the briefs on this. Mr. Hiven, if you would, please recess court till 3:30.
This honorable court is now in recess until 3:30 p.m.